Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a beautiful case law decided by Honorable Justice D.Y. Chandrachud regarding the application of Section 311 CRPC. While allowing the application for re-examination of witness under Section 311 of the CRPC in the case of Varsha Garg versus State of Madhya Pradesh in criminal application number 1021 by 2022 on 8th August 2022, Honorable Justice D.Y. Chandrachud held that the production of the decoding registers and summoning of the cellular service provider authorities, yes, definitely it can be allowed because it's a case involving the brutal killing of an advocate, and as a matter of legal right, yes, they have got a right to produce the documents. The court is correct. Of course, actually they did not accept, but the application is correct to call for the decoding registers and to examine the cellular company service providers as witnesses. So, to tell it is very easy, but why this complication has arisen? You have to go to the facts of the case. Then only you will be able to understand. As already narrated by me, that this is relating to the murder or brutal murder of an advocate, Varsha Garg's husband. He was murdered right in front of his office on 18/11/2015 at about 11:30 p.m. or so. While he was about to come out from the office, yes, due to fire shots, they shot him from the near range and he died. Right. So immediately reported the matter to the police. A case in crime number 734 by 2015 under section 302 read with 34 IPC was registered in Mahau PS MHOW of Indore district. Right. So death is due to the firearm. Please remember, even the PM certificate also clearly held that he died of the firearm injuries. Right. So the investigation was taken to the police. They arrested 6 accused and ultimately they filed the charge sheet also. The charge sheet was taken on file. It was committed to the Court of Sessions. Then SC number also given and the trial started. I think trial started in the year 2017 itself. Yes. 2017 the trial started. Actually in the charge sheet the IO has actually stated that there is a CD but he could not produce. CD means that is compact disc relating to Idea, Vodafone, Reliance and another company. Vodafone, Reliance and some other company, I don't remember correctly. So all cellular companies. The nodal officers were examined as witnesses on 17/11/2017, right, and up to 2018 they were examined. Please remember, the IO annexed the certificates issued by Airtel, Reliance, Idea and Vodafone because it is in 2015, right. Now later actually the IO was also examined as PW 47. He said that he did not produce the certificate as required under section 65B of the Indian Evidence Act. What is the 65B? You have to know. So definitely we all know that the so-called evidence of that watch evidence, the online virtual evidence is 100% allowed. That means if you take a videograph or if you take a photo, allowed. But the thing is, you have to give a certificate on section 65B that with this phone, with this cell camera, I have taken this and I am producing this. That is also to be produced. That mobile phone also has to be produced. Or at least certificate has to be given. This is a self-deciding certificate. So nobody, no others can give a certificate. You have to fill up the certificate. It's a simple pro forma. I don't know why he have failed to give the certificate. So during the course of investigation, he realized that he did not give the certificate. Therefore, a petition under section 311 CRPC has been filed before the court. What for? To summon the so-called service providers like Airtel, Vodafone. Why? Actually, the court has taken into consideration of his request and took the CD also. but the CD is found to be corrupted because it has been there for about 2 years or so. It's corrupted. So original CD or another part will be with the Airtel or Vodafone people. Therefore, the investigating officer filed a petition, and on behalf of the investigating officer, additional PP will do it, or PP. Filed a petition to reopen the case under section 311 CRPC. But the trial court, ADJ, rejected the same, stating that already the evidence has been recorded, and today is the day at the 3:15, the examination of the accuser under 313 CRPC is also over. They have denied the offense. Now the prosecution evidence is closed. Today the prosecution evidence is closed. How can you file a petition for reopening? So he rejected. Then the matter, once again the revision petition was filed before the Honorable High Court of the Madhya Pradesh. But High Court also stated that, opined that the decoding registers are not part of the CD. It is not part of the charge sheet. Decoding registers you have not mentioned. You have mentioned only that you have collected a CD or the call details, certificates dated 11/1/2016, 18/1, 13/33/2016, like that, all dates he has given. So this was there, but the CD was not there. Now you are saying, so not allowed. It is a belated thing. So please remember, neither they were mentioned in the charge sheet, and the evidence is already closed, and now it is a belated issue. Now you have opened your eyes. So that's why vigilantibus stantibus. So the law will come to the rescue of the person who opens his eyes, but not the person who sleeps. But the matter has come before Honorable Justice D.Y. Chandrachud. The revision. So this Varsha Garg, who is the wife of that slain advocate, she did not keep quiet. She approached the High Court, Supreme Court also. Now, Justice D.Y. Chandrachud held that it is a murder of an advocate, number one. Number two, the decoding registers are essential for the decision of the case. Why? Call details can be decoded, or details can be decided only through the decoding registers. Definitely very good evidence. So the relevant material which was not brought into the existence of the charge sheet or into investigation, into the record, due to inadvertence. So we can't keep quiet. You can't close your eyes. So still there is a time for taking a decision. So therefore, since only the matter is the evidence on the part of the prosecution is closed, but so much of things are there. So therefore, give a chance to them. So the application to file the petition under section 311 CRPC for recalling the witnesses has been allowed by the Honorable Supreme Court of India. Very good judgment. Please read it and enrich your legal knowledge. Thank you very much.